Hi, I'm Scott Brown of Scott Brown and Associates. I'm board certified in family law, and my law firm specializes in divorce and family law. Many clients, they have questions about what happens if they are being denied possession and access with their children. So that's the topic we are going to cover today. My ex won't let me see my children. What can I do? Now, tell me if this sounds familiar. Lately, every time you are scheduled to visit with your children, your ex comes up with some excuse to keep them away from you. You've tried to be patient, but now you're wondering, what can I do? What are my options when my ex is not allowing me to see my children? So here are some reasonable steps that you can take before you take your ex back to court. First, start a conversation. Now you might be thinking, I have talked until I am blue in the face. But consider whether all that talking was a conversation or an argument. Can you express your concerns to the other parent in a safe environment, outside the children's presence, without the conversation devolving into a shouting match? If so, schedule a time and a place to meet. If your ex isn't speaking to you or you can't have a civil conversation, then joint sessions with a therapist or a trained counselor might be helpful. Another option is mediation. Mediation might be a good option if some time has passed since the custody and visitation order first was entered, and you or both of you would like to renegotiate your time-sharing arrangement. Another option is to lay out your dispute in writing and send your ex a letter by certified mail. Outline every time he or she has violated your visitation rights and request immediate compliance with the court's order. If that doesn't work, have an attorney send a formal demand letter. Sometimes a letter from an attorney is all that is required to get the other parent to cooperate. If none of these approaches work, then it's time to seek court intervention. Now, a court has the power, number one, to issue an order granting you extra time with your children to make up for the time you were denied. Number two, the court can modify the existing order so that it meets the specific needs of your children and your current situation. This could include giving you primary custody of the children and allowing the other parent only limited or supervised visitation. Third, the court also has the power to hold the non-complying parent in contempt of court for his or her behavior in intentionally disobeying a court order. The punishment for contempt may include community service, a fine, or even jail time, and also the reimbursement of your attorney's fees. Now, your case will be strengthened by all of your good faith efforts to resolve this issue prior to coming to court. In addition, there are 3 things you can do before your court date to help bolster your case. The first is to be a good record keeper. Hold on to every document related to the custody and visitation dispute. Keep a log of all communications between you and your ex. That includes text messages, that includes emails, Facebook posts, Facebook Messenger. Document everything. Secondly, keep a visitation journal. Your journal will serve as a contemporaneous record of your efforts to see your children and can be powerful evidence of the harm you and your children have experienced because of the other parent's violation of your visitation rights. The third thing you can do to help bolster your case is to enlist the help of a family law attorney. If you need a judge to resolve your visitation dispute with your ex, then you need an attorney on your side to assert your rights and ensure that you and your children's best interests are protected. When you're ready to talk about your situation, give us a call. Call us at 979-849-8526 and schedule a consultation. We look forward to seeing you.